A contractor prices a massive design-build project, signs the contract, and locks in a lump sum budget. The dirt starts moving, the steel goes up, and everyone assumes the commercial baseline is set in stone. Then, midway through construction, the government issues a new environmental mandate. Suddenly, the project requires entirely different materials, extensive redesigns, and costly new safety protocols. The contractor looks at the ballooning expenses and refuses to absorb the hit. The employer points back at the signed lump sum agreement and expects the work to be completed for the original price. When a project hits this specific stalemate, the FIDIC Yellow Book uses Sub-Clause 13.6, Adjustments for Changes in Laws. This clause provides the path for adjusting the price or the timeline, but only if the claimant successfully navigates a sequence of procedural filters. Before we break down those filters, make sure to like and subscribe for more deep dives into engineering and legal mechanics. Understanding how these rules function is the difference between a project that adapts to legal shifts or one that stalls in a gridlock of litigation. The first filter is chronological. To measure risk, FIDIC uses a concept called the base date. This acts as a contractual snapshot that freezes the legal environment for the purpose of tender pricing. If a regulation or permit requirement existed before that snapshot, the contractor is assumed to have accounted for it. If you try to claim a cost increase for a law that was already on the books, the claim fails immediately. A claim can only proceed if the legal change was officially published in the post-tender zone. That proves it was impossible for the contractor to price the risk ahead of time. Without identifying the exact base date, any argument about fairness or unexpected costs is contractually irrelevant. A change in laws encompasses new statutes, revised permit conditions, shifting authority rules, or even new official interpretations. However, a new rule simply existing is not enough. There is a strict causation requirement. The change must tangibly impact the contractor's project obligations, forcing them to do additional work or alter their schedule. When a contractor proves this impact increases their expenses or causes delays, they can claim compensation for that cost and an extension of time, bringing the project's economics back into balance. This also works in reverse. If a legal change, like a dropped tariff, makes materials cheaper, the employer is entitled to claim a reduction in the overall contract price. Subclass 13.6 is a bilateral tool. It ensures that neither party unfairly profits or is unfairly penalized when the external legal environment shifts. Even when the facts of a legal change are clear, you can still lose your entitlement if you ignore the contract's procedures. To claim money or time, you must follow Subclause 20.2. This requires formal notices, continuous contemporary records, and detailed particulars connecting the legal event to the actual impact on site. Failing to submit those notices within the required timeframe invalidates your entitlement. Under FIDIC 2017, the claim is lost entirely, regardless of the merits. If the new law forces a physical change to the works, like mandating different safety equipment, the engineer must also trigger the variation procedure under Subclause 13.3. Resolving a legal change requires managing two distinct tracks: the administrative path for financial relief and the engineering path for physical construction changes. Let's return to that industrial plant. When the contractor was hit with the new environmental regulation, they successfully secured an adjustment because they passed every filter. They documented the base date, proved cost causation, followed the Subclause 20.2 notice timeline, and secured a formal variation for the new equipment. In projects that rely on informal site agreements, these legal shifts often lead to disputes that outlive the project itself. By following the contract precisely, both parties protected their interests and kept the project on track. This highlights the core lesson of FIDIC. The contract is governed by structured fairness, which relies on facts and evidence rather than assumptions of goodwill. Subclause 13.6 provides the mechanism for recovery, but that recovery is only available to those who maintain the procedural discipline to document their case.